Dear Chief Acosta, my employer is implicating me in a certain offense which I allegedly committed against the corporation. I believe that I will eventually be dismissed, so I am contemplating whether to resign and file a complaint later for illegal dismissal. Please enlighten me on the matter. Yuri.
Dear Yuri, resignation is voluntary on the part of the employee. Pursuant to Article 300 of Presidential Decree Number 442 or the Labor Code of the Philippines as amended and renumbered.
An employee may terminate without just cause the employer-employee relationship by serving a written notice on the employer at least 1 month in advance.
On the other hand, dismissal is involuntary on the part of the employee as it connotes termination of employment initiated by the employer on account of just or authorized cause provided under Articles 297 to 299 of the Labor Code of the Philippines. Based on the nature alone, resignation and illegal dismissal are incompatible. As such, an employee who voluntarily resigns from work and files a complaint later for illegal dismissal will have no legal ground to stand on. This is also in consonance with the ruling in the case of Vance versus University of St. Anthony, where the Supreme Court, speaking through Honorable Justice Ramon Paul Hernando, stated that
The court hold the petitioner's voluntary resignation effectively rendered their complaints for illegal dismissal without any basis. Central Azucarera de Baez, Incorporated versus Yason, discusses the concept of resignation. Resignation is the formal pronouncement or relinquishment of a position or office. It is the voluntary act of an employee who is in a situation where he believes that personal reasons cannot be sacrificed in favor of the exigency of the service, and he has then no other choice but to deassociate himself from employment. The intent to relinquish must concur with the overt act of relinquishment. Hence, the acts of the employee before and after the alleged resignation must be considered in determining whether he in fact intended to terminate his employment. In illegal dismissal cases, it is fundamental rule that when an employer interposes the defense of resignation, on him necessarily rests the burden to prove that the employee indeed voluntarily resigned. For resignation from employment to be valid, there must be an intent to relinquish the position together with the overt act of relinquishment. Resignation must be voluntary. In illegal dismissal cases, the employer, if defense of resignation is presented, must show that the employee indeed voluntarily resigned.
to determine the intent of the employee to terminate the relation, his or her acts before and after the alleged resignation will be considered. Further, the voluntariness of the act will be confirmed. If both are present, the resignation of the employee will effectively render the subsequent complaint for illegal dismissal without any basis. In your case, your intention to resign is clear. Nonetheless, the voluntariness of your act depends on the underlying facts. If you are resigning simply to avoid being terminated, then your act could be considered as voluntary. We hope that we were able to answer your queries. Please be reminded that this advice is based solely on the facts you have narrated and our appreciation of the same. Our opinion may vary when other facts are changed or elaborated. Tomorrow, we'll look into another question from our viewers and readers of Dear PAO. This is your host, Dr. Persida V. Rueda Acosta, the Chief Public Attorney of the Republic of the Philippines. Goodbye for now.